Yes.
Please, Madras.
Made, please, my lord.
Made, please, my lords.
Lords, we are unable to see the honorable court, madam. Made, please, my lord.
Made, so please,
Yes.
my lords.
My lord,
Please, my lords.
I beg to appear for the petitioners in my lord's WP 2880 of 2022.
My lords, I appear in 2146 of 22,
Please-
which is the
please-
first case.
Please give the name.
Yes, my lord.
My lords,
That is Miss Aisha. Sanjay, if I don't know. Miss
yeah,
Aisha
let me.
Shifa.
Mine is the first case. If your lordship pleases, writ petition 2146 of 22. It is Aisha
21?
Hajir Almas,
2146 of
22.
yes.
Aisha Hajir Almas. That is the case from Udupi. My
Yes.
learned friend appears, Mr. Devdutt Kamath appears in the
Lords,
case
in
from Kundapur.
2880 of 2022, my lords. Lord, this petition was heard, my lord, before the learned single judge, my lords, at length on day before yesterday. So, my lord, if I can just make a few brief, my lord, submissions, then my learned friend can. My lord,
You
Yes,
are
that-
appearing in 2880.
that's right, my lord. That's right, my lord. My lords, I have
Look,
prepared a
Devdutt,
brief written note. My lords, Sanjay, just
may I begin? I have something which will save the time of the court. Please, my
Yes.
lords. My lords, there are several cases out here, and the referral by the learned single judge was largely on the question of whether this is an essential religious practice, and that question no doubt squarely arises. It was heard at length. Mr. Kamath is right. He did address the court for nearly a day on that. But, my lords, there is also a principle in law which says that constitutional questions necessarily be decided if they can be decided on other statutory grounds. My lords, in this case, it will be my respectful submission that while I fully adopt and I will be also arguing the constitutional questions, there are also statutory questions and questions on the rules on which the facts of this case may be disposed of.
Yes.
Please, my lords. My lords, the lead judgment for this principle is a judge.
We will have to understand what are the questions involved.
Please, my lords.
Then only we can decide.
that's right, my lord.
Please, my lords. My lords,
First, give the key facts of the case.
please, my
Give
lords.
the key facts of the case and then come to the legal position.
Please, my lords. The brief facts
Yes.
of this of the case that I represent, which started off this entire chain of events, arise from my hometown of Udupi, my lords. In
Yes.
the PUC, in the government PUC college
Is it fine?
there, 2146 of 2020.
2146.
My lords, in this petition, the brief facts are set out at para 5 on page 12.
Yes, a direction has been sought to attend classes with their head scarf without
Please,
any
my lords.
bias and discrimination.
Please, my lords.
Yes.
My lords, may I just place the facts as to what happened? And I'm aware that there is no counter as yet filed by the private respondents because they probably were served only yesterday. My lords, it appears to me on my reading of the facts,
Whether the state has filed
the state has filed a response. The state has filed a comprehensive response on law. On law.
All right.
Please, my lords. The only reason that I'm placing the facts are that it appears on my reading of the facts
Yes.
that it was a small thing within a college, which probably due to lack of timely administration has been allowed to go beyond control. Para 5, my lords, may I read? May I please? Para 5
Yes.
of the petition, my lord. I'm sorry, my lords, I was waiting for. There seems to be some disturbance, but if your lordships can't hear me, please tell me.
Yes,
Please,
yes,
my
we are,
Please, my
yes,
lords.
we are hearing you. Yes.
Please, my lords. The petitioners are students of the government pre-university girls' college and are wearing their regular headscarf over the college uniform. And respondents 6, 7, and 13, who are teachers there and the principal, insisted that the petitioners remove the headscarf by shaming them due to their conduct and invoking their religious identity. In fact, in spite of this, the petitioner continued the same, convincing their alma maters that it is part of their religious and social culture and wearing headscarf is not coming in the way of school discipline and their education. In the month of August 2020, respondents 6 and 7 rebuked the petitioners and told them that their parents had sent consent letter at the time of admission, accepting terms and conditions of the school, and specifically admitted that their wards won't wear the headscarf, so now they can't breach the same. Respondents number 6 to 14, whenever they found the petitioner anywhere in the college, scolded them, threatened them with marking absent in their attendance and not awarding internal marks. Respondent number 13 specifically informed petitioner number 5 that in the past also some girls used to wear headscarf to teach a lesson to them. She incited other students to pull their scarf. If you and other students don't fall in line, they will have to face the same treatment. Since September 2021, the petitioners faced discrimination in their class, and whenever the respondent took their classes, removed the petitioners from their class, marked them absent, made them stand outside as the class as punishment, and it is still continuing till today. In the month of December, parents of the petitioner went in to speak to the respondent number 6, that is the principal. He replied that now exams are going on, he will discuss the issue after exam. And when they demanded about the consent letter, which the college teachers used to refer to the petitioners, then the respondent number 6 candidly accepted that there's no specific condition regarding the headscarf, and it is common form regarding maintaining school rules and discipline. From the last week of December 21, after the exam class teacher did not allow the petitioner students to allow class, used to send into the respondent number 6 office to take permission and inform them either to remove their headscarf or get permission from the principal through their parents. Even when their parents came to college to speak to the principal, respondent number 4, they compelled them to wait the whole day without meeting. The conduct of the respondents 4 to 12 appeared to be to frustrate the petitioners and their parents and compel them to concede before them. On 30th of December 2021, seeing no result, the students approached respondents 3 and 4, who are the district education officers, with their representation to intervene in the matter, finished their ordeal, and after receiving the representation, respondent 3 called the principal and scolded him for not allowing petitioners to attend class and directed him to allow the student immediately. Copy of the presentations are there. On 1st of January 2022, New Year's Day, respondent 6, the principal, called a meeting of the College Development Committee, which had no legal sanctity and in composition of political entities, to interfere in the management and functioning of the college for the political agenda. The chairman of the CDC, respondent 15, declared that the petitioners will not wear headscarf. If they continue, then the other students, according to their narrations, Hindu students, will wear mufflers, saffron shawls to counter them and blend the issue into a communal color. After this meeting, the petitioners were not allowed to attend the college on all working days and were made to sit outside of court classroom like a culprit on 13th January. Seeing no hope and being targeted from every corner, petitioners thought of doing a protest in front of their college gate along with their petitioners to seek their right of education, which was continually denied. At that time, respondent 6 principal called the local media at the instance of respondent 16, the MLA, which took petitioners with placard to circulate in social and electronic media to divide society. Then on 14th of January, the petitioners went to the college. That time, the principal called them in his chambers, scolded them for conducting protests in front of college and making a media issue. Subsequently, he called the respondent to write an apology letter. The respondents threatened petitioners with their gestures and gave a blank paper to forcefully write apology. When they refused, they called respondent number 13 as well, who manhandled them physically and threatened to spoil their education completely, and they cannot help as entire system is against them. Then, my lords, then other leaders got on, but this is the basic conspectus. So the reason
we understood the problem. Yes.
Please, my lords.
This is
my respectful submission is that I have gone through the entire act, through the rules, and also an interpretation of the rules. My respectful submission is that in the act, in the Karnataka Education Act of 1983, there is no specific provision which deals with uniform.
Do you mean to say that there shall not be any uniform?
Please, my lord, I don't mean to say, let me complete the argument. My lords, there is no provision for a uniform. The state relies on certain rules, which
just one thing. We will just make a request to the media in general that please don't report any observations made by the court during the arguments without seeing the order which we will pass ultimately. So there is a request to the media in general that please don't report our observations in the media, but in social media, in newspapers or anywhere else, unless you go through the order which is passed or you understand the entire thing. It is not proper that only some observations are reported here and there without realizing the repercussions of that.
Oral observations.
Yes, oral observations.
We are really grateful, my lord.
We
are really grateful for that, my lord, because sometimes
yes,
whatever your lordships, my lord, speak, sometimes is reported, misreported, etc. We are really grateful, my lord, for that observation.
Yes,
we are grateful, my lords. My lords, while I was preparing for this matter, I recollected that your lordship is from Lucknow, which speaks of delicacy of language and exquisite manners, my lords. And there is a phrase from Lucknow which would help all of us. Muskuraiye aap Lucknow mein hai. And it is in that spirit.
aap Bangalore mein.
Bilkul. My lords, the thing is that matters may appear big, matters may have grave consequences.
Yes.
But if there is a certain lightness of touch and an openness of heart, there is nothing that this country cannot achieve.
Yes.
My lords, so I was on the point that in the 1983 Act, there is no provision for uniform. And my lords, let me tell my lords that I was in Karnataka, in college, in Pius College, around that time, 1980 to 1982, I was in pre-university there. And we did not have any uniform. The question of uniform in not being in the Act was probably because at that point of time, the educational experience was, and seriously, that many a time a child could not go into a school because the parents could not afford uniforms. That time there were no government schemes for provision of uniforms. Sometimes there were cases where two children shared one set of uniform, so one child went to school, the other child did not. And so uniforms, by and large, were a school phenomenon, and primarily because it was easy to identify school children if they got lost, if they ran away from school.
Yes.
And when young teenagers on the verge of adulthood stepped into junior colleges, stepped into colleges, they walked out of uniform. Uniforms for college, my lords, came in much later, and they have come in due to the application of rules. And if memory serves me right, it all started in Tamil Nadu in a set of institutions, private institutions, which were engineering colleges with the ODR group of institutions, which were owned by a former policeman. And from there on, it came back into the colleges because there was some feeling that uniforms in colleges would prevent fashion shows and whatnot. This is a broad history of the event. It need not trouble your lordships. I'm only putting it in the context of why there is no provision for uniform in the Act. Now, there are two sets of rules. There are please, my lords.
Yes.
There are the Karnataka Educational Institutions Classification, Regulation, and Prescription of Curricular Rules of 1995. The 95 rules have rule number 11, which the state relies on.
Yes.
My lords, there the rule says, please, my lords, just give me 1 minute. And keep the 2006 rules. Provision of
'95. Yes.
provision of uniform, clothing, textbooks, etc. Each recognized educational institution may specify its own set of uniform. Such uniform, once specified, shall not be changed within the period of next 5 years. When an educational institution intends to change the uniform as specified in sub-rule 1, it shall issue notice to parents, etc., etc. And then purchase of uniform and textbooks from the school or shop and stitching of uniform with tailors shall be at the option of the student or his parents. These rules, in my respectful submission, basically were for schools. If your lordship sees, that will be, these rules are intended to cover largely the schools. Your lordships will see that rule 3, which would illustrate prescription of classes relating to primary and secondary education for the purpose of clause 25 and 32 of section 2. Primary education shall be classes from 1st to 7th standard, with 1st to 4th as lower primary, 5th to 6th as upper primary. Secondary education shall have classes from 7th
Say that
standard.
provision of rule 11 is not applicable to pre-university institutions.
Please, my lords. Pre-university is 2006. And the 2006 rules no provisions for uniform.
Yes.
Now, my lords, what the state and the college authorities rely on is a resolution which my learned friend, Mr. Tahir, if he is in court, will probably hand over in a separate printout,
Yes.
which has a prescription of a uniform for in this particular case. There, it is, I
660.
because the original is in Kannada, my lords, and my lords, there also is a translation that we have attempted. But in a sense, the prescription is at clause 4, if I'm not mistaken. Which roughly translates into the school uniform which was used last year, that is blue color chudidar pant, white and blue checks, top and matching color shawl to be worn on the shoulders.
Yes.
Please, my lords. Now, my lords, there is, as I told your lordship, A, there is no provision. B, there is no penalty. In case the uniform is not worn or improperly worn or incorrectly worn, there is no prescribed penalty. And even if there was a penalty, which was prescribed, your lordships could have then checked on whether such a penalty of absolute expulsion, keeping children away totally from education, would be proportionate. My lords, if your lordship, I'm sorry, I'll wait.
Yes.
If your lordship turns to the Act itself, the Karnataka Education Act of 1983, the penalties prescribed in Chapter 17 are also largely for college managements. Section 113 onwards, my lords. My lords, largely they are financial. It will be punished with a fine which may extend to 25 rupees for contravention of Section 17. If a parent fails to comply with an attendance order passed under Section 17, he shall on conviction be punished with a fine not exceeding 2 rupees. Then there are penalties for ragging, for copying at exams, loitering near an examination center, malpractices, and so on and so forth, my lords. But because there was no provision for a uniform, there is also no question of any penalty for want of a uniform or for an infraction of the uniform code. Now, please, my lords.
Yes.
Now, my lords, to make things simpler and specifically because we are in a video conference, my lords, I would request my learned friend, Mr. Tahir, to hand over my submission only on the administrative law aspect of this matter. My lords, I have separately drawn it up. I've separately drawn it up. As far as the constitutional questions are concerned,
Lords, just one, Lordships may, Lords, hear us at your Lordship's pleasure. But just one fact which I wanted to bring to your Lordship's notice, my Lord, is that in Mr. Hegde's petition, my Lord, there is a subsequent GO which probably has not been impugned. And my Lord, that GO is the basis, my Lord, of the further action which has been taken by the state. So therefore, my Lord, the state today is contending that there is a GO. Pursuant to the GO, my Lord, there are certain consequences which follow. So, my Lord, Lordships may have to hear, my Lord, the GO issue first, because all this petition was filed prior to the GO, my Lord. So therefore,
It is for you people to decide who will argue first.
yes, my Lord. So I would request,
will
my
not
Lord,
decide.
since the GO, since the
We will not
GO,
decide who will argue first.
yes, my
Whether
Lord.
please, my Lord, let me complete.
Yes, yes. So I was only requesting, my Lord, that Mr. Hegde will bear with me. I'll just finish, my Lord, in half an hour, not more. So because this my learned friend's petition doesn't concern the GO at all, my Lord.
No, Mr. Kamath.
Yes, my
Since
Lord.
Mr. Hegde has started the argument,
Yes, yes, my Lord.
let him complete his argument. Make
Very well,
let
my
him
Lord.
make
Yes,
his
my Lord. As
submission.
far as
Then
the
you
GO
argue.
is concerned,
We
since
are
I
not
thought,
in
my Lord,
hurry. We
yes,
will
ma'am.
hear you all at length.
We are grateful, my Lord. We
Because we
are
will assure
absolutely
you-
confident, my Lord.
Yes.
And actually, we are grateful that your Lordships took so much, my Lord's interest and, my Lord, constituted the bench, my Lord, despite the pressure of your Lordship's time. We are, my Lord, really grateful for that, my Lord.
Now let him complete his submission. Then you
Yes, my
argue.
Lord. On the GO, I will make submissions, my Lord.
Oh, yes, Mr. Hegde.
My Lords, I have one request from Mr. Hegde, my Lords. I am for the non-state parties contesting respondents. I would request Mr. Hegde to instruct his juniors to email that note, my Lord, so that we can follow what he's saying. We are in different locations. We don't have the benefit of that note.
It will be done. It will be done in the next.
You both are
Oh, I'm
friends.
sorry, I'm sorry,
Yes,
my Lord.
my Lords.
I,
My Lords, friends and neighbors in Delhi, my Lords.
Yes.
we are neighbors in Delhi, but Mr. Puvaya is today in Bangalore, I believe.
No, I don't.
My Lord, and in fact, when I said Muskuraiye Lucknow mein hai, it was Mr. Puvaya who first called me up and said, smile a bit more when he saw me rather. Please.
Yes,
I'm sorry, my lords. I have one request for the court master. My junior who's assisting me Mr. Pranjal Kishore keeps getting logged out from the proceedings and he can't follow instructions. He's in the waiting room. If he may kindly let in.
Please.
Somebody.
Add him.
Please, my lords. Please send written submissions over to Mr. Puvaya and the others and anyone else. Please, my lords.
Yes.
My lords, the petitioners.
Written submission, Mr. Hegde, for the final hearing.
My lords, for the final hearing, insofar as the administrative law aspect is concerned, if your lordship wants to wants me to concentrate on the interim order today.
No. We are not saying anything.
Please,
we have just started the hearing.
Please, my lords.
We just want to understand
Please,
that in what manner you people want to argue.
Please, my lords.
If it is for the final hearing, well and good. There's no problem.
Please, my lords. My lords, I am mindful of court's time. I'm also aware of the pressures on the court, specifically in constituting a 3-judge bench, which would also involve that many other benches get disrupted and many people. It is my respectful submission, my lords.
Yes, it is good of you that you are mindful of that, and let us.
My lords, that is why, my lord, I second, my lord, what my learned friend has said. Would your lordships hear us on the interim, my lord's arrangement? Because lordships, my lord, will decide this issue finally, my lord. There is no difficulty, my lord. Your lordships, my lord, are under pressure of time. Lords, we are in your lordships' hands. But, my lord, the urgency is this, that, my lord, these students, my lord, are outside the college. My lord, their classes, their exams are, my lord, supposed to be held sometime in March, my lord. There is an urgency, my lord, that at least some interim arrangement in the meanwhile should be worked out.
made.
My lords, let me complete. My lords, I have not
Addressing
finished.
lordships, finally, my lords. In fact, my lord, then I would submit before your lordship, there is some subsequent development which has taken place in this matter.
Yes.
And the subsequent development which has taken place is quite grave. I must bring to lordship's notice is that pursuant to this petitions being filed before your lordships, on the allegation that they were kept out because they were wearing headscarf. But unfortunately or fortunately for whatever reason, there have been another set of students who are coming now to the colleges wearing bhagwa or saffron shawls, saying that that also depicts our religious symbol and we must be permitted. But this led to large amount of commotion and some sort of disturbance in educational institutions, for which the state government took a decision to close down the institutions for 3 days, which expires on Friday. But it's in this context, in fact, I wanted to make that submission before your lordship, but since Mr. Hegde started, what I can. Therefore, in that context, my submission before your lordships would be notwithstanding the claims and counter claims which is sought to be made before your lordships, an arrangement requires to be made, which would be conducive ultimately for the educational institution concerned. Now, but as on today, there is a order passed by the state government stating all that we have said is each educational institution shall decide its own uniform. We have not said that this should be the uniform, this should not be the uniform. Now, pursuant to which some institutions have taken a decision what should be the uniform. The question is whether any of the students would, in disregard to that, those decisions will go and take part in the institution. Pending that, but now of course, for two broad issues. One, now they have said that the government did not have the power to pass an order. Secondly, the larger question of Article 25, which they say is inherent within the religion, its activity itself. It's part of an integral part of the religion to wear a headscarf. Therefore, by preventing me from participating in the institution, you are violating 25. That seems to be the larger argument. Pending that, lords, my submission and my lords may straight away record my submission. We need to start the institution. We want the children to come to the college, but we can't start the institution in this atmosphere where one set of the students say they will come and wearing headscarf, the other person say that we will have shawls, etc., depicting their religious symbol. We say that we want to start the educational institutions. We want a very congenial atmosphere among students. Pending disposal of a final adjudication, this is one option which the lordships may kindly examine. But they must go back to the status quo ante. But
Lord, there is absolutely
any particular.
Lord,
Let me complete what they have.
I'm sorry. I can't see, so I don't know. I'm sorry.
Without insisting on any particular dress code, whatever has been prescribed by each of the college development council, they must adhere as on today. Subject to, of course, not finally if lordships are to hold that there really exists the fundamental right, then consequences. But this is something which I want to place on record. So as a state board, we are concerned with the apart from the law and order situation about the right of the students today. There are large number of students who are no way concerned with them, but they have been now kept away from the educational institution. It has to start in this manner. I'm placing on record this arrangement will cause no prejudice. In fact, it will facilitate the running of this education.
We think that the first concern of everyone should be that at the earliest, the education institutions shall reopen and they shall start imparting education to the students. All these issues which are there, they are before the court, and then the court will consider them.
Absolutely.
But whatever is that, we all have to agree that some sort of arrangement shall be made where the education shall not suffer.
Absolutely.
Not only that,
we don't think that there can be any dispute to this. That our endeavor should be that the education of the students shall immediately start and without any disturbance.
And because of this pandemic, already 1.5 years the students have left kept away from
yes, now things were coming to back to track, coming to track again, but now this issue has started where the schools have to be closed. This is not a good situation.
It's not a good thing, but this has to be diffused. But therefore, this arrangement,
My lords, I completely agree, my lord, with what the learned AG has said, that the schools and colleges should reopen at the earliest. And my lords, there is absolutely no joining hands, joining issue with that, my lord. And my learned friends also will agree. My lords, what I was suggesting is, as Mr. Hegde put it, my lord, this is not a case of uniform, my lord. My lords, nobody is saying, this is not a case, my lord, where the students are saying we will wear a different uniform. Please, my lord, as far as my clients are concerned, this is not the issue at all. The issue is simply this: the students will wear the school uniform. The only question is, my lord, that they want to wear a headscarf of the same color as the uniform. And my lord, the state is today saying by a GO that they can't wear that headscarf. Lord, that is the crucial issue. It is not about uniform, my lord. And therefore, my lord, I respectfully submit that in the interim, my lords, my lord, these students have been, my lord, going to the school wearing the uniform and, my lords, wearing their headscarf. My lords, let that, my lords, situation continue. Let your, my lords, lordships, my lord, take whatever time it takes, my lord, to decide this issue. In the meanwhile, my lord, it is their customary practice, lords, to wear a headscarf over the head, my lord. And there are traditions which are there all over the country, my lord, and these are innocuous traditions, my lord. It doesn't harm anybody. This is not a question of public order. This is not a dangerous practice, my lord, where the state comes in and says, no, this offends somebody else's right. So therefore, in the interim, my lord, let them continue wearing the same uniform, my lord, the headscarf of the same color, and let them commence going to school, my lord. And what the state, just one more submission, my lord. The state today says, my lord, I heard the learned AG saying that, look here, we have not done anything. We have only asked the school committees to take a decision. My lord, this is totally wrong. The state, my lord, is playing, my lord, by the fire. And I want to say this. In the GO, my lord, kindly see the GO. The GO has not been placed before your lordships. The GO says, my lord, kindly, if my learned friend can just give an English translation to the Honorable Court. The GO says, my lord, that the headscarf is not a part of religious practice. My lord, and then the state, and thereafter, my lord, the discretion has been given to the state committee to decide. Now, my lords, our fundamental rights in this country, my lord, be subject or hostage to some school committee. Lord, is it what the state is saying? Just have a look at the GO, my lord.
Kindly, that the English
Lord,
translation.
I want to make submissions. Now, I didn't interrupt the learned. There has to be some discipline, my lord.
Kindly see the
Lord, I am making a submission.
6 to 5 to.
Lord, I am making a submission. The AG will not, my lord, interrupt me. Lord, we are in your lordship's hand. This is the court of law. And I hope, my lord, there is freedom of speech and expression here. Lord, just have a look at, my lord, the GO. We have made an English translation. And if I can just place, I had placed this before Honorable Justice Dixit, my lord, for at length. But if I can just place this GO, my lord, this is the basis of the state's decision. Lord, if I can just skip the recitals, just have a look at, my lord, page 2. Just before the quotation, my lord, the question relating to uniform dress code over individual dressing choices has come up in several cases before the Honorable Supreme Court and High Courts. And then, my lords, one, Kerala High Court is cited. Number 2, my lords, over the page, my lord, a Bombay High Court judgment is cited. Number 3, my lord, there is a Madras High Court judgment which is cited. And see the last paragraph, my lord, on this page. And this is what I was talking about, my lord. This is not as innocuous as the learned AG says, oh, we have not done anything. We have left it to the local committees. As mentioned in the aforementioned rulings of the Honorable Supreme Court and various High Court, since the prohibition of a headscarf or a garment covering the head is not a violation of Article 25. Additionally, in terms of the Karnataka Education Act, the government has decreed as below. Then, my lords, over the page, this is the order. This is as far as schools are concerned.
That order is important. That order is what is binding
My lord,
upon authorities. That is not
my lord,
operating.
I don't understand, my lord, this kind of anxiety by the learned AG. We are, my lords, making submissions. We are not on the street. I respect the AG immensely, but I think at least a little bit of that modicum of respect should come back.
I am saying is, now that I am saying.
Lord, I am making a submission. Learned AG will not interrupt.
The operating portion of the
Lord,
order.
please protect me, my lord. This is not the way, my lord, the AG of a state should, my lord, argue a case. My lords, I am making a submission. Just have a look at the order, my lords. The last paragraph. In colleges that come under the pre-university education department's jurisdiction, the uniforms mandated by the college development committee or the board of management should be worn. In the event that the management does mandate a uniform, students should wear clothes that are in the interest of unity, equality, and public order. Now, my lords, by itself, my lord, it may sound innocuous, but what precedes this order is the declaration of a law which the state is entirely incompetent to, my lords, make, that hijab or wearing a headscarf is not a part of religion. And that is why, my lord, this challenge to the GO is crucial. My lord, we are not concerned, my lord, with whether the committee has the power to do it, whether, my lords...
Mr. Kamath,
yes,
we will now consider
yes, my lord.
now this issue
Yes,
that
my lord.
as whether the wearing of headscarf
Yes, my lord.
confers any fundamental right
Yes, my lord.
under Article 25.
Yes, my lord. That's the heart of this case, my lord. That's the heart of this case. Your lordships have...
Now, that question would be considered by us.
Yes,
now.
my lord. Yes, my lord. But I am saying, my lord, since it's an issue of fundamental rights and lordships, my lord, as a constitutional court, my
There's
lord.
one more question which
Yes,
may require consideration
Yes, my lord.
as to whether wearing of this headscarf
Yes, my lord.
is an essential part of
Absolutely,
religious
my lord.
practice.
Absolutely, my lord.
Yes, my
my
lords.
Then
lords,
only
on the
comes the
interim
fundamental right.
arrangement, my lords, on the
Then
interim
only
my
the
lords.
arrangement,
question
my
of
lord.
fundamental right. First,
Yes,
you
my
will have to address as to
Yes,
whether it is an essential part of the
Absolutely,
religious
my lord.
practice.
My lord,
My lords,
Then
there
question
is
comes
plenty.
under Article
Lord,
There is
25.
plenty
I'll
that
go
I
down,
will
my lord.
place.
Lords,
There
what
is
I was
plenty
saying is,
that
my
I
lord,
will place.
just as in any case, my lord, for the interim, lordships will have to be satisfied, my lord, that the petitioners before your lordships have a prima facie case. There is a balance of convenience. And, my lord, a third principle of irreparable injury. And what I wish to submit, my lord, that I want to make a prima facie case.
That is why, Mr. Kamath, we
Yes, ma'am.
asked Mr. Hegde
Yes,
as
my
to
lord.
whether he is taking his submission finally on the
Yes, my
final
lord.
hearing of the matter or for the interim purpose.
My lords, I
Now,
was,
Please, my lords. May
I
I
was
answer?
he-
The
I was
question is to
He
me.
was he-
Mr.
that for
Kamath,
the
the question
interim-
is to me.
yes, my lord.
The question is to me, my lords.
I have no
And,
difficulty. Let
and-
Mr. Hegde, thereafter I'll answer, my lord.
Please, my lords. My lords, I do not like my arguments being anticipated on my
Yes.
side.
Definitely.
Please, my lords. And here, my lords, there are two parts of the argument. There is as far, and that is why I was trying to ascertain the convenience of the court. Primarily, it is this. If we go into the question of essential religious practice, I place the Quranic verses, I place the commentaries on it, and thereafter, your lordships hears Mr. Kamath, your lordships hears the Advocate General, and it goes on. I can assure your lordships that it will take time, and it will not. And if I may use the phrase, it may take God's good time.
It will take time. You cannot.
It will take God's good time. But there are children, there are girl students who have a very difficult problem. It is very easy for the Advocate General to say, let them just go back. But should they, having taken a conscientious decision, freedom of conscience is also assured to every citizen, irrespective of majority or minority. Should they, in the interim, stifle their conscience and go back into school? Is that the piece that is? My lords, I have some experience of this state. I have been at Standing Council for 10 years. I know the problems of administering. And my lords, there was particularly the time when Mr. Rajkumar was kidnapped, where we had Justice Bharucha in the Supreme Court handling the case. And when we told Justice Bharucha that, sir, if anything happens, there would be anarchy, he looked at us and said that if you can't rule according to the law, quit. Where I have, and my lords, thereafter, the matter went on for a long time, and ultimately it got resolved. There are some things which can wait for resolution. There are some things where before the fire comes, it has to be doused. And that is why I kept on to the smaller argument. My lords, I've also handled this state when the chief minister of the state went on a padayatra during the Kaveri time, and we had to answer an angry Supreme Court. There have been times I know where wisdom lies in not being maximalistic, where wisdom lies in trying to find a middle path which everybody can safely tread on till such time that there is a judicial resolution.
Yes.
My lords, I am reminded of how there was a huge problem in Delhi when Mandal came in. And it was the Supreme Court where Justice K.N. Singh of who had originally come from your lordship's Allahabad High Court said, it's our children who are dying there. Today, all that I'm requesting the state to say is that irrespective of what kind of dress, what kind of food, what kind of faith, they're all our children. They're all our girl children. And this is not a case only about essential religious practice. It is a case of essential education for the girl child. And so if there is a state, I will prove that there is no rule. I will prove that there is no guideline on this. However, even assuming today that there is this resolution of a college committee, which reads, my lords, let me make a confession. I can't read Kannada. I'm reading Kannada from the Roman script, but I can speak Kannada. And
I can neither read nor speak.
Yes, therefore, my lords, the college requirement is ಬಿಳಿ ಬಣ್ಣ ಮತ್ತು ನೀಲಿ ಬಣ್ಣದ ಚೆಕ್ ಸ್ಟಾಪ್ ಮತ್ತು ನೀಲಿ ಬಣ್ಣದ ಪ್ಯಾಂಟಿನ ಕಲರಿನ ಭುಜದ ಮೇಲೆ ಹಾಕಿ ಕೊಳ್ಳುವ ಶಾಲ್, which basically means the same color as the pants, as the chudidar or the shalwar. You will have a shawl or a dupatta on your shoulders. Students, my girl children, will adhere to that. But if they tuck that same chudidar over their head, nobody should, consistent with their faith, nobody should have an objection. And particularly, my lords, I showed your lordships the pleadings. This is something which can be resolved at that PUC college level. A wise administration, a wise government will issue the necessary instructions. Today, your lordships may consider it. If your lordships gives a clarification that those children can go back to school, they will be wearing the uniform. How they wear the uniform or a part of the uniform consistent with their faith is up to them. Nobody should have any objection whatsoever. That is one way of sorting it out. That is one way of sorting it out in the interim. And that's the course of wisdom, even if it is I who says so. There are very deep-seated questions of identity here. Is it essential religious belief? I heard the Advocate General yesterday say that there are 2 verses of the Quran and there are multiple interpretations. To which my most respectful answer is, my lords, that it is my religious faith as a lawyer of this court that the Constitution of India is supreme. And there may be one article here and one article there. There may be a 14 here, there may be a 21 there. There may be multiple interpretations of what 14 and 21 are, but there can be no manner of doubt that they all come to the aid of every citizen, for the butcher and the baker and the candlestick maker, to use Justice Vivian Bose's quotation from The Owl and the Pussycat. So here, my lords, I do not wish to add any fuel to any fire. The first thing that this state needs is for the children to return to school, for peace to return, and the atmosphere of tenseness to calm down. This is a state which cannot afford any kind of disturbance. This is the state which contributes the maximum to India. I was very proud when I used to represent it in the Supreme Court to say that we probably provide more in income tax than almost per capita than almost any other state in India. This is a state which has contributed the maximum unicorns to the Indian economy. I would not want it imperiled. And if a problem can be confined to a small place in an easy manner, I would request your lordships, in your wisdom, to suggest to the state and to work out something. My lords, it does not, leaving it to the College Development Committee would, I agree with Mr. Kamath there, would not be healthy. The College Development Committee, the local MLA, everybody has their own calculus. I'm not saying right, wrong, or the other. They may not see the big picture. They may not have had the benefit of working so much on the law over so many years. Today, my lords, if the Advocate General of the state could be asked to do something that in a manner consistent with the dignity of everyone. After all, what is the preamble of the Constitution? What is it? After everything it says, consistent with the liberty and dignity of the individual. This is a question of a woman's perceived sense of identity and dignity. Of a girl child who, like in my hometown of Udupi, we had Kanakadasa, who was excluded from the Udupi Sri Krishna temple. We had the father of the Constitution, Dr. Ambedkar, when he went to school, was told to sit slightly apart on a sackcloth apart from his students. After so many years of the Constitution, after so many years of the Republic, my lords, I do not want any kind of separation. We are a country which is like no other. We are a mix of so many influences, so many kinds of people. I explained things to my brother's mother-in-law, who's a white American, that there is one operating principle in India, which if you know, everything works. And she asked, what is that? I said, sometimes we have to kindly adjust. That one word, that adjust, kindly adjust. Well, Lords, that is reflected in the last words of the Supreme Court of Justice Chinnappa Reddy's judgment of the Supreme Court in Bijo Emmanuel, my lords. My lords, Bijo Emmanuel, the last line, if your lordships just gives me a minute. Is that we only wish to add, our tradition teaches tolerance, our philosophy teaches tolerance, our constitution practices tolerance. Let us not dilute it. My lords, if the learned Advocate General could be asked that is there some way, and I am willing to sit with the learned Advocate General at whatever personal cost or whatever, to sort things out. But if your lordships could ask the state, why is it why do we state unnecessary pride or whatever on, why do we stake our country on some one particular version, that this and this alone is the path? My lords, we are a country, we are a civilization of multiple paths.
My lords, if my learned friend has finished, then only I'll start. Yeah. My lord, I completely subscribe, my lords, to what my learned friend has, submitted. My lord, this suggestion had also come, my lord, from the bench when my lord's Honorable Justice Dikshit was there, and this was put to the Learned Advocate General. Learned Advocate General, my lords, frankly said that, my lord, nothing may be possible, and thereafter, my lord, lordship started the hearing. Even at this stage, my lord, if the Learned Advocate General says something can be worked out, that, my lord, we continue to go to school wearing only our headscarf with the same color, my lord, we would be too happy, my lord, and the lordships can decide this matter, my lord, in the fullness of time. But if that is not my lord, possibility, then I would urge your lordships to kindly hear us, my lord, on the prima facie case, balance of convenience, and just give me, my lords, 15-20 minutes. I will show, my lord, that this whole geo is nothing but a sham, my lord. I can show that, my lord, in just 10 minutes. And my lord, lordships may ask the AG if something is possible. I will not argue, my lord. There's no difficulty at all. But we would all like, my lords, that the matter can be resolved at least at the interim stage without, my lords, having to trouble your lordships. But if that is not possible, my lord, I respectfully submit, my lord, that lordships will hear us on the interim relief. That's all, my lord, at this stage.
In continuation with Mr. Kamath has submitted a very short submission in support of the petitioners. But this was suggested before His Lordship Mr. Dikshit also. I may request, but this is more a question of attitude, at least for this interim statement. Of course, we can be rather argue for days and days together. All that I am submitting, if there is a correct attitude on this, if there is a correct attitude, the state is actually winning, not losing. But when
Are
some
you representing anyone?
I am, my lord, in repetition civil number 2347/2022, where I made a submission before His Lordship Justice Dikshit also. His Lordship was pleased to entertain the submission. Probably I am in continuation with that. IA number 7 is the IM. I am only on a very short issue. I am not arguing the matter. I am only suggesting 1 minute will be enough. What I am suggesting is this. But if the state is benevolent enough to understand the situation and to take an interim measure to entertain these students with the dress, with the attire, because why I am submitting, your lordship knows, but we have a constitution which says 25 explanation says, but even the kirpal is permitted. But this was the submission which I was trying to make before the Justice Dikshit also, kirpal. And there is a Punjab and Haryana High Court judgment. Despite the inherent danger with a kirpal may pose, this is the constitution which has accepted that. There's a Punjab and Haryana judgment on that. There's also a judgment of a foreign court. All that I submit. If they feel that this is harmless, this is not that harmful. If the dress, if the attire is not that harmful, they can take a view on this. And that's what I'm saying.
The student of University of Oxford, and is not a party to the proceedings, not a petitioner, etc. Therefore, this application now they have filed to intervene in the matter as an impleading applicant in this petition. Obviously, they have no locus onwards as a party. So if Mother friend wants to implead himself, then an application has to file. We'll file our statement of objections. Only then, after impleading clauses may hear, we'll have one. Because this will become very difficult for number of impleading applicants, subject to what ultimately launch.
Lord, sir. So therefore,
but I do not know how.
So there doesn't seem to be much of a consensus, my lord, on an interim arrangement. So we will not waste your lordship's precious time, my lord. Just give me 20 minutes, my lord. I will demonstrate, my lords, a prima facie case for grant of an interim order, my lord. just have a look at, my lord. I have
Without
prepared.
Without interruption, my lord, the one IA which the learned AG was referring to is in fact IA number 6 of 2020. I think the AG is slightly getting confused between the two IAs. There are two interlocutory applications filed. One is by a Oxford University PhD student who is working and researching on discrimination.
That's all right, ma'am. That's all right, madam.
Yes,
Let's go on merits.
Yes.
My lords, may kindly, my lord, just bear with my lordships. I've heard Mr. Hegde, my lord.
No,
Just
I have not
give me 15,
completed.
20 just give me
I've not-
15, 20 minutes, my lord, on prima facie case. And my lord, thereafter, my lord, lordships will take a call because it's already 3:45, my lord. Lord, just give me 15,
I had
20
not
minutes.
completed.
Yes, my lord. Lord, just give me 15, 20 minutes, my lord. On prima facie
Mr.
case, my learned friend has argued on the law. As far as
Our
the,
request is that all should argue one by one.
yes, my
We
lord. Yes, my
cannot
lord.
hear the arguments in piecemeals.
Yes,
Let
I
Mr.
follow that,
Hegde
my lord.
complete
No,
his
your lordships are
argument.
hearing us on interim. My learned
Let
friend
him
stopped, my
complete
lord.
his
That's why.
argument, then only you argue.
Yes, my
I,
lord. My learned friend has stopped. That's
I
why-
yielded to the Advocate General, who
Yes.
has a right of audience.
Correct.
Otherwise, the normal rule is that the court hears one petition after the other.
Very, very well. I
And
noted that.
so since I was placing the first petition, my lords, even on the prima facie a case, my lords, if your lordship comes back to my written submissions,
Yes.
because that will also make out my case on prima facie. It had my written submissions were in a separate
Yes.
volume. Your lordship has.
Yes. There
Please,
is the
ma'am.
memo.
Please, ma'am. The petitioners are Indian women who have been denied access to classroom education. This is on the sole ground that they chose to wear a hijab. The petitioners contend that the actions of the state and colleges are illegal, as the Karnataka Education Act and the rules made thereunder do not prescribe a uniform. Even assuming that a uniform is mandated, there is no punishment prescribed for failure to wear a uniform. The right to wear a hijab falls within the ambit of the right of expression guaranteed by Article 19(1)(a), the right to privacy, and also the freedom of conscience under Article 25 of the Constitution. The same cannot be infringed upon without a valid within quotes law. My lords, I have the background for this is a preliminary submission on constitutional avoidance, where the Supreme
We have
Court, following
understood, Mr. Hegde, we have understood Karnataka Education Act do not prescribe a uniform.
please,
There
madam,
is no punishment prescribed for failure to wear a uniform.
Please,
Now,
madam.
so far as this submission, right to wear a hijab falls within the ambit of the right of expression guaranteed under Article 19(1)(a),
please,
and
madam.
the right to privacy and also freedom of conscience under Article 25 is concerned. Do you
madam.
want to elaborate? You
My
want
lords,
to elaborate?
there is an elaborate written submission in there. But my request today is simply this. That the normal rule of constitutional adjudication is that if your lordships can dispose it off on a smaller question without going in to the larger question of the hijab, then your lordships will go there. Will necessarily go use that, and that is what the Supreme Court has held. If your lordship sees at page 2, I am of the opinion that a case which can be decided of without deciding constitutional questions should be so determined without expressing an opinion on the constitutional questions raised, unless absolutely necessary for the purpose of deciding the case. I do not think. Please.
That stage is not now, because already the learned single judge has said that these issues now involve important constitutional issues, which require to be determined by the larger bench.
Please.
So now you are before the larger bench. So
Please,
now these are the constitutional issues which are required to be considered. So we
Please,
cannot
madam.
say that without referring to the constitutional issues, we can decide the matter now.
Please, madam.
What what we I feel is that that stage is now over.
Please, my lords. If you,
Since the matter has come up before the larger bench.
the second submission. Please, my lords. My lords, may I request my learned friend, Mr. Tahir, to give the second set of submissions on the larger issue. I had separately put it in two separate headings, one on the smaller issue, one on the larger issue. Mr. Tahir, I can't make out whether he's in the courtroom. I'm sorry. I'll wait. Has my lord got it?
Yes.
Please, my lords. In the Court and National Legal Services Authority, 2014 5 SCC 438 has recognized that clothing and appearance fall within the ambit of the right of expression guaranteed under Article 19(1)(a) of the Constitution. In Jigya Yadav versus CBSE 2021 7 SCC, the court was dealing with CBSE bylaws that restricted a student from changing his name in the records. So, para 125 thereof, I've put in all the passages for ease. Identity, therefore, is an amalgam of various internal and external, including acquired characteristics of an individual, and name can be regarded as one of the foremost indicators of identity. And therefore, an individual must be in complete control of her name, and law must enable her to retain as well as to exercise such control freely for all times. Such control would inevitably include the aspiration of an individual to be recognized by a different name for a just cause. 19(1)(a) of the Constitution provides for a guaranteed right of freedom of speech. In the light of Navtej Johar, this freedom would include the freedom to lawfully express one's identity in the manner of their liking. In other words, expression of identity is a protected element of freedom of expression under the Constitution. In this case, wearing of a hijab is an expression of religious identity. The same is a right protected under 19(1)(a) of the Constitution. It can only be curtailed by way of reasonable restrictions under the grounds mentioned in 19(2). None of the grounds are made out in this case. It's also relevant to submit that the state has a positive obligation on the state to create and maintain conditions in which the freedoms guaranteed by the Constitution can be exercised. In the state of West Bengal case, the court held the freedoms which are guaranteed by 19 are universal. 19(1)(a) stipulates that all citizens shall have the freedoms which it recognizes. Political freedoms impose a restraining influence on the state by carving out an area in which the state shall not interfere. Hence, these freedoms are perceived to impose obligations of a restraint on the state. But apart from imposing negative restraints on the state, these freedoms impose a positive mandate as well. In its capacity as a public authority enforcing the rule of law, the state must ensure that conditions in which those freedoms flourish are maintained. In the space reserved for the free exercise of speech and expression, the state cannot look askance when organized interests threaten the existence of freedom. The state is duty-bound to ensure the prevalence of conditions in which those freedoms can be exercised. The instruments of the state must be utilized to effectuate the exercise of freedom. when organized interests threaten the properties of theater owners or the viewing audience with reprisals, it is the plain duty of the state to ensure that speech is not silenced by fear of the mob. Unless we were to read a positive obligation on the state to create and maintain conditions in which freedoms guaranteed by the Constitution can be exercised, there is a real danger that art and literature would become victims of intolerance. In the present case, we are of the view there has been an unconstitutional attempt to invade the fundamental rights of the producers, the actors, and the audience. My lords, then, if I may skip over the rest of that passage, if your lordship permits the next one, the right to privacy, the freedom of conscience, and the right to practice, profess, and propagate religion are explicitly recognized under Article 25. The Supreme Court also recognized the freedom of conscience to be part of the right of privacy. In Puttaswamy, the court observed, while the right to freely, this is para 372, while the right to freely profess, practice, and propagate religion may be a facet of free speech guaranteed under 19(1)(a), the freedom of the belief or faith in any religion is a matter of conscience falling within the zone of purely private thought process and is an aspect of liberty. In the specific context of appearance and clothing, the court observed, the choice of appearance and apparel are also aspects of the right of privacy. The freedom of certain groups of subjects to determine their appearance and apparel, such as keeping long hair and wearing a turban, are protected not as a part of the right of privacy, but as a part of their religious belief. Such a freedom need not be necessarily based on religious beliefs following under Article 35. These are from the opinion of Justice Chelameshwar. Once it is established that the freedom of conscience forms a part of the right of privacy, any infringement thereof has to be tested on the touchstone of the triple test laid down in Puttaswamy at paragraph 310 and reiterated in the 5-judge judgment of Puttaswamy. To constitute a valid infringement of privacy, there must be an existence of a law. And that's why in my earlier submission that there is no law. B, a legitimate state interest. C, that the law must be proportionate. In this case, neither the 1983 Act nor the 95 rules prescribe a uniform or prohibit the wearing of a hijab. Thus, the first requisite, that is the existence of a law, is not met. My lords, then my submissions under 25 are that 25 of the Constitution confers two distinct fundamental rights. One is the freedom of conscience. Second is the free profession, practice, and propagation of a religion. The right under Article 25 is made subject to public order, morality, health, and other fundamental rights. Article 25 rights are conferred upon communities as well as individuals. The vast majority of cases adjudicated by constitutional courts deal with the second aspect of 25, that is free profession and practice and propagation of religion. These cases have broadly involved the determination of practices that can be understood as a group or community practice. This court, the Supreme Court has held that only an essential religious practice is protected under Article 25. My lords, while arguing before Justice Dikshit, I mentioned that too was a great case which came out of the same town of Udupi, my hometown. That was in the Shirur Mutt case, where the Supreme Court first said, it propounded that yes, what is protected under Article 25 is the essential religious practice. In this case, the petitioners claim the right to wear hijabs on the basis of their individual freedom of conscience, as well as on their right of religion. The lead judgment on the freedom of conscience is Biju Emmanuel, which is 86.3 SCC, which dealt with the issue without going into the question of essential religious practice. It ultimately held that we are satisfied. My lords, may I request here that your lordship kindly turn to the judgment of Biju Emmanuel itself, which is there in the compilation, which may have been handed over to your lordships. 203. I do it for a particular purpose. because the facts in Biju Emmanuel are strangely somewhat like the facts of what happened here. At 207, my lords, of the compilation.
Yes.
203. It starts at 203 and is at 207. The three child appellants, Bijo, Binumol, and Bindu Emmanuel, are faithful of Jehovah's Witnesses. They attend school. During the morning assembly, when the national anthem is sung, they stand respectfully, but they do not sing. They do not sing because, according to them, it is against the tenets of their religious faith. Not the words or the thoughts of the anthem, but the singing of it. This day, and before them, their elder sisters who attended the same school earlier have done all these several years. No one bothered, no one worried, no one thought it disrespectful or unpatriotic. The children were left in peace and to their beliefs. This was until July 1985 when some patriotic gentleman took notice. The gentleman thought it was unpatriotic of the children not to sing the national anthem. He happened to be a member of the Legislative Assembly. My lords, I read my pleadings, and here also, my lords, ultimately, constitutional rights, constitutional beliefs cannot necessarily be led to the adjudication of politicians, whether they happen to be members of parliament or members of the Legislative Assembly. Ultimately, it is the Constitution that protects all citizens, irrespective of whether they happen to be in power or out of power, elected or unelected. My lords, after these facts, if your lordships, before I've placed that conclusion at page at paragraph 25, but there I would also want to place before your lordships para 90, which I think is important. Para 19 is at page 214. May I read, my lords? As my lords,
Yes.
I have all my lords got it, please. Para 19. We see that the right to freedom of conscience and freely to profess, practice, and propagate religion guaranteed by Article 25 is subject to public order, morality, and health, other provisions of Part 3 of the Constitution. Any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice, or B, providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all sections and classes of Hindus. Thus, while on the one hand, Article 25(1) expressly subjects the rights guaranteed by it to public order, morality, and health, and to the other provisions of Part 3, on the other hand, the state is given the liberty to make a law to regulate or restrict economic, financial, political, or other secular activity which may be associated with religious practice, and to provide for social welfare and reform, even if such regulation, restriction, or provision affects the right guaranteed to them by 25(1). Therefore, whenever the fundamental right to freedom of conscience and to profess, practice, and propagate religion is invoked, the act complained of as offending the fundamental right must be examined to discover whether such act is to protect public order, morality, and health, whether it is to give effect to other provisions of Part 3, or whether it is authorized by a law made to regulate or restrict any economic, financial, or political or secular activity which may be associated with religious practice, or to provide for social welfare and reforms. It's the duty and function to do so. Here again, as mentioned in connection with Articles 19(2) to 6, it must be a law having force of a statute and not a mere executive or a departmental instruction. Here, my lords, Shirur Mutt is quoted, the portion from Lathan, and then what is religion is also quoted, my lords, at paragraph 20. My lords, there is also one passage at para 22, which probably reflects what the dilemmas that the Advocate General and the government are facing. In the middle of para 22, Justice Jackson referred to Lincoln's famous dilemma. Must a government of necessity be too, and the emphasis on strong, for the liberties of its people, or too weak to maintain its own existence? And added, it may be doubted whether Mr. Lincoln would have thought that the strength of government to maintain itself would be impressively vindicated by our confirming power of the state to expel a handful of children from school. Such oversimplification, so handy in political debate, often lacks the precision necessary to postulates of judicial reasoning. If validly applied to this problem, the utterance cited would resolve every issue of power in favor of those in authority and require us to override every liberty thought to weaken or delay execution of their policies. Governments of limited power need not be anemic government. Assurance that rights are secure tends to diminish fear and jealousy of strong government, and by making us feel safe to live under it, makes for its better support. Without promise of a limiting Bill of Rights, it is doubtful if our Constitution could have mustered enough strength to enable its ratification. To enforce those rights today is not to choose weak government over strong government. It is only to adhere as a means of strength to individual freedom of mind in preference to officially disciplined uniformity, for which history indicates a disappointing and disastrous end. Justice Jackson ended, if further below, Justice Jackson ended his opinion with the statement, if there is any fixed star in a constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. We think the action of local authorities in compelling the flag salute and pledge transcends constitutional limitations on their power and invades the sphere of the intellect and the spirit, which is the purpose of the First Amendment to our Constitution, to reserve from all official control. And so, thereafter, I've already placed para 25, my lords, and that last sentence at para 27. So, my lords, now my comment at para 10 of my written submission. It is clear from the above that the issue as formulated by the court was not whether refusal to sing the national anthem was an essential religious practice to Jehovah's Witness. Rather, the issue was whether the person claiming a religious exemption was doing it on the basis of their bona fide faith. My lords, then assuming that the essential religious practice test applies, the wearing of a hijab is essential to the Islamic faith as far as women are concerned. And the High Court judgments have been set out, my lords. The first is the 2015 judgment, where the single judge observed, it cannot be ignored that in our country, with its varied and diverse religions and customs, it cannot be insisted that a particular dress code be followed, failing which a student will be prohibited from sitting for the exams. It directed that at the two centers indicated in the writ petition, the invigilator, along with a woman invigilator or other authorized officer, shall be present half an hour before the examination commences. The petitioner who intends to wear a dress according to their religious custom, but contrary to the dress code, shall present themselves before the invigilator half an hour before the exam, and on any suspicion being expressed by the invigilator, shall subject themselves to any acceptable mode of personal examination as decided by the invigilator, but however carried on by an authorized person of the same sex. If the invigilator removes the headscarf or full sleeve garments to be removed and examined, the petitioners shall subject themselves to that by an authorized person. It's desirable that the CBSE issues general instructions. It came up again before another single judge, and Justice Mohammad Mushtaq Mellots considered the place of hijab under Islamic law. And in paragraphs 20 to 29, Mellots, since it has placed extensively by Mr. Kamath, I've not, and then at para 30, the discussions as above would show that covering the head and wearing a long sleeve dress by women has been treated as an essential part of the Islamic religion. It follows a fortiori that Article 25(1) protects such please, Mellots. And then there was a balancing done by the court at para 36. The court, taking note of the practical difficulty of the board for the conduct of the exam, provided sufficient safeguards. The court was of the view that the same can be followed for this year as well, and board can take necessary steps for the next year onwards while inviting applications itself to protect such rights. It is to be noted, practical difficulty cannot be an excuse to dishonor the fundamental rights. Therefore, this court is of the view that for this year, the board shall permit all candidates who, based on religious practice, want to wear the headscarf and full sleeve dress to appear for the exam. This court need not interfere with the dress code prescription as referred in the prospectus, as others are bound by such prescription, except to hold that the dress code as above shall not be enforced against the candidates who, by virtue of Article 25, are protected from wearing such dress as prescribed in the injunctions of their faith. The writ petitions were accordingly allowed. The CBSE appealed the decision to a division bench. However, by the time the matter was heard, the CBSE had issued a notification. Besides, para 15, Mellots, besides the fact that the wearing of hijab has been found to be an essential religious practice, one other aspect is of the court in those cases was dealing with a temporary prohibition. Mellots, the temporary prohibition was that during exams do not wear the hijab, because sometimes these days with modern technology, with Bluetooth, with whatnot, a hijab might be useful. For that purpose alone, even there where there was a prescription, the court said, okay, this is how we balance it out. Come half an hour earlier, make arrangements so that if anybody wants to check you with it, it can be done. The other judgment that the learned advocate general had also pointed out was, Mellots, I have stated in paragraph 16, but that, however, was a private school and perhaps also a Christian minority institution. And when the balancing happened there in para 17, the petitioners cannot seek imposition of their individual right as against the larger right of the institution. It is for the institution to decide whether the petitioners can be permitted to attend the classes with a headscarf and full sleeve shirt. It is purely within the domain of the institution to decide. The court cannot direct the institution to consider such a request. This judgment may, if I were to distinguish on facts, private institution, minority institution, and the court was balancing two fundamental rights. As against this, in the facts of our case, this is a government institution which belongs to every citizen, or every inhabitant of Karnataka to every citizen of India. There are all kinds of inhabitants, there are all kinds of citizens. Now, can you, by a rule, make for a set of citizens or inhabitants that you may have to forsake an essential tenet of your faith at the time that you attend the institution? If you say that, then where is the overweening state interest that this alone will be done, that you will attend in this manner alone and in no other manner? Where does it satisfy the triple test which has been laid down in Puttaswamy? There is nothing. And therefore, what your lordships is called upon, even at the interim stage, is to find the right balance.
Yes.
And as has been submitted, my lords, here there's a prima facie case. There is also the balance of convenience in my favor, that denial of the right to attend the college would have irreversible consequences. I would implore my lords not only as far as the education of these children are concerned, everybody, in the interest of everybody's education, to find the right balance. And before I go, one thing I wanted to point out, that there are specific provisions in various central enactments which actually permit face coverings. If your lordship sees section 129 of the Motor Vehicles Act, there, I'm sorry, it's not for face covering. It's not for face covering. 129 of the Motor Vehicles Act provides that the provision shall not apply to a person who is a Sikh if he is, while driving or riding on the motorcycle, wearing a turban. So you don't need a helmet. Similarly, in the Supreme Court rules, there are rules specifically made for the benefit of Pardanashi in women. Order 9, Rule 8, which says that where the deponent is a Pardanashi lady, she shall affirm or take oath before a lady registrar of the court, which shall include an additional registrar duly authorized. So the provisions, there are provisions which specifically authorize. Today, the provisions do not specifically take away, but in practice are being so implemented in this institution so as to effectively render it nugatory. It could be clarified to the institution. If the Advocate General says that it can be done on the state aspect, your lordships may consider the weight of it. Otherwise, your lordships would be required to pass interim orders, my lords. And I submit that in this case, there should be interim orders which would protect the right of these students. So, and particularly so, as far as these petitioners are concerned, it's a question of 2 or 3 more months of attendance. My lords, I'm very grateful for a very patient hearing, my lords.
Thank you.
May it please, my lord. My lords, I beg to appear, my lord, in WP 2880 of 2022. And I will be very brief, my lord. And I will concise, my lord, my arguments only for the purposes of, my lord, interim relief, which your lordships may kindly consider.
We are appearing in 2347.
No, my lords, 2880 of 2022, Miss Aishat Shifa versus State, my lord. My lord, I will not trouble your lordships with the facts. My learned friend, my lord, has taken your lordships through some of the facts which arose in his case. But the only fact which I want to mention, my lord, which we have said in our writ petition, is that these are students, my lord, who were wearing a headscarf and going to college for the last 2 years. They are, my lords, 12th standard students. For the last 2 years, my lord, they were wearing a headscarf and going to college. Till, my lords, 3rd of February, they were stopped and said that unless you remove the headscarf, you cannot go in. Lords, apart from those facts, my lords, I don't want to trouble your lordships with the facts. My lords, my case for an interim relief today is based on 3, my lords, broad considerations. Number 1, my lords, I want to satisfy your lordships that this GO which has been issued on 5th of February 2022, firstly, my lord, suffers from a total non-application of mind. And I'll just make that good, my lord, by taking your lordships to the GO. And that will be my first ground, my lord. The second ground, my lord, I want to say that wearing a headscarf, my lord.
This government order is
Yes,
of
my lord.
5th of
Yes, my lord, I'm grateful, my lord. My lords may kindly just have
translation which you had.
That's right, my lord.
Right.
That's right. The Kannada version is there in the writ petition, my lord, at page 20. Yes, my lord. If I can just, my lord, place the GO itself, my
Yes.
lord, kindly turn to page 2, which I had just read, my lord, in my opening. The paragraph 3, the question relating to a uniform dress code over individual dressing choices has come up in several cases before the Honorable Supreme Court and High Court. And my lord, 3 decisions are cited, 1, 2, and 3 over the page, and a conclusion is drawn. Kindly see the next page, my lord. The conclusion is drawn that these 3 judgments say that hijab or a headscarf is not a part of Article 25. And that, my lord, I respectfully submit, is a result of a total non-application of mind, because these 3 judgments don't say that at all. Lord, the entire basis of this GO is high courts have held that this hijab is not a part of Article 25. And I'll prima facie demonstrate, my lord, that this is not so. If your lordships can have the compilation which I had, my lord, given to the Honorable Court. My lords, this is a compilation, my lord. I request Shaul to kindly hand over the compilation to volume 1 to the Honorable Court. And I'll show, my lord, all these 3 decisions are totally, my lords, against the state. Just, my lord, if I can just place those decisions quickly, my lord. If my learned friend can just hand it over to the court master to give it to the Honorable Court. Volume 1, yes.
Their understanding, what you have to say on that.
I'm
It is
sorry.
their understanding which they have
Yes,
drawn.
my lord. That's right, my lord. I am saying, my lord, I am saying that understanding is totally incorrect, my lord. That's for your lordships
Yes.
to, my lords, lord, decide. And I'll show that, my lord.
Thing is that come to the operative portion of the government order.
Yes, my lord. I am
What does
saying,
it say how it affects? How
the
it
reason is this.
the right?
If the decision, my lord, at the penultimate paragraph, that, my lord, there is no prohibition of, my lord, Article 25 as far as wearing a headscarf is concerned. If that goes, my lord, this is totally innocuous. This is, my lord, you deal a body blow.
It is come to the operative portion. What
I
operative
go down, my
portion?
lord. I am saying, my
By
lord,
the institutions or the persons on whom this is binding, they
Right,
have to go by the operative portion of the government order.
but they
What
will
does
also be
what does
guided.
the government order says?
Yes, my lord.
in operative-
I am extremely grateful for that question, my lord. They will also
That
be
may be
guided,
the
my lord.
foundation for this.
Yes,
That all those what have been earlier said,
yes.
it may not have been said.
Lordships
It
may,
is a foundation for this,
Yes.
whatever the operative portion says.
yes, my lord. But ultimately, the building is built on the foundation, my lord. The foundation is this, foundation is that prohibition of headscarf is not a violation of Article 25. And it's an enabling provision, my lord, for the colleges to now say, and which they are saying, my lord, that look here, you can't wear a headscarf. I am saying if the foundation goes, my lord, the building can't stand. So therefore, my lord, the foundation itself is totally questionable, is what I am saying. Now kindly see these three judgments, my lord, which the state relies upon. And then, my lord, I'll just make that good. The first judgment, my lord, which the state relies upon is, my lord, a ruling of a writ petition 35923. My lords, that your lordships will please find at page 39 of this compilation.
39.
Yes, my lord.
Yes.
Totally, my lords, inapplicable to the facts of this case. Just have a look at page 39. Religious dress. I'm sorry, my lord.
Yes.
My lord has page 39, my lord.
Yes, page 39 of your
Yes, my lord.
compilation.
Yes, my lord. Religious dress in a private educational institution is an issue in this writ petition. My lord, the Chief Justice got it.
No, the compilation which you have passed on, this
My lord,
one.
page 39, this compilation, my lord, it starts with Fatima Hussain, my lord.
It is not on this.
My lords, I don't know, volume 1, which we handed over to the Honorable Learned Single Judge, my lord.
Which has been given to us is volume 2.
No, volume 1. I'm sorry, I think they have made a mistake, my lord. I'm so sorry, my lord. Volume 1, I was requesting. I'm so sorry, my lord, to waste the lordship's time. I'm so sorry, my lord. My apologies.
Yes.
Lords, since it is virtual, my lord, we are unable to, my lords, properly assist your lordships, my lord, whether it is, my lord,
It is not
correct
virtual.
papers or-
It
Yes.
is not virtual. We
Yes.
are in a hybrid mode.
Yes, my lord. I'm sorry, my lord, since
Our
I am
court is full of
addressing the lord-
lawyers.
Yes, my lord, since I am addressing your lordship,
Our
I
court
am
is
at a
full of
handicap.
lawyers.
Yes, my lord, I am at a handicap, my lord. That's why I'm not in assisting your lordships, my lord. Lords, may kindly have page
No
39.
choice that you are appearing by virtual mode.
Yes, my lord. Lords, page 39, my lord, of this, if your lordships may kindly see. Yes, my lord. Yes, my lord. This is the first decision which is cited in the GO. And kindly see, my lord, what is the issue here? Religious dress in a private educational institution is an issue in this writ petition, not a government college, my lord. Then, my lords, kindly turn over the page. I just invite lordship's attention to paragraph 4, what the learned single judge says. The
What has
court,
been held in this judgment?
yes,
What has been held in this judgment?
lords, what the court says, my lord, that ultimately, my lord, a private minority educational institution cannot be forced, my lords,
Where it has
to
held?
admit. Yes, my lord. Yes, straight away, my lord. My lords, may I just place that straight away, my lord? My lords, may kindly first turn to paragraph 4. This first paragraph 3, my lord. One has the liberty to follow his own notions and convictions in the matter of dress code. At the same time, when such a right is claimed against a private entity, kindly see this, my lord, which is also having equal fundamental right to manage and administer an institution, this court has to balance competing fundamental rights and decide the issue. Now see paragraph 4, my lord. This issue, this court by judgment in Anna bint Bashir versus CBSE had taken a view that a right of a woman to have the choice of dress based on religious injunctions is a fundamental right protected under Article 25 when such prescription of dress is an essential part of religion. Therefore, there may not be any difficulty to hold that it is the fundamental right of the petitioners to choose the dress of their own choice. Then, my lords, paragraph 5, my lord, that is the Article 30 right is discussed, that is of a minority institution. And then, my lord, may turn over the page. Paragraph
Yes.
10, my lord, page 41.
Come to paragraph 7.
7, my lord, I'll read it, my lord. Fundamental rights are either in the nature of the absolute right or relative right. Absolute rights are non-negotiable. Relative rights are always subject to restriction imposed by the Constitution. The religious rights are relative rights. In the absence of any restriction placed by the state, the court need not examine the matter in the light of the restriction under the Constitution. The court will therefore have to examine the matter on a totally different angle on the conflict between fundamental rights available to both. The court has to examine the prioritization of fundamental rights in a larger legal principle on the legal system function in the absence of any constitutional guidance. In this regard, the Constitution itself envisages society where rights are balanced to subserve the larger interest of society. So, my lord, in the context of Article 30, the court says you have to balance the fundamental rights. So, what your
If
lord
they have considered this judgment,
yes,
the larger public interest
yes, my lord,
while issuing this government order,
yes, my lord.
they have to
My lord,
balance. They have
yeah.
to balance the rights of both the educational institution and the individual religious rights.
Correct, my lord.
Now, considering this judgment, what is wrong?
No, my lords. What I'm saying is this. This decision, my lords, was in the context of a private minority institution which has Article 30 right. Right, my lord? Now, the same learned judge, my lord, when it comes to a government institution, please see his approach. And that is why I just wanted to place, my lord, page
We are
24.
not here to judge the approach of the judge individual.
Yes, my lord.
That is not for us to see.
No, I kindly see, my lord, what has been held, because that will probably assist
you
your lordship.
examining. You said that they have totally non-application of mind.
Yes, my lord.
Consider these judgments,
Yes, my
which
lord.
have been referred in the government order.
Yes, my lord.
Now we have pointed out the paragraph 7 of this
Yes.
judgment to you
Yes,
to
yes.
show that in order to balance, to subserve the larger interest of the society, they
Yes,
have,
madam.
if you consider this government order, what wrong they have done.
I
This
bow
is
down,
what-
my lord. That's a very important question which your lordships is posing me. But this decision, my lord, was in the context of a private minority educational institution which has a separate set of fundamental rights, my lord, under Article 30 of the Constitution. My lord, lordships are very well aware, my lord. So therefore, this
private education institutions are also under the Constitution.
I bow down, my lord.
It is-
I bow down, my lord.
Only thing is that they have got some additional right
Yes.
to manage the institution under Article 30.
And my lords, their right, my lord, to admit students of their choice is
It does
totally
not mean-
unfettered, my
It
lord.
does not mean that the general law will not apply to them.
I bow down, my lords. I bow down. Now, my lords, kindly see what happens in the context of a government institution. Just see, my lords, page 24, if your lordships permit, page 24. So the first decision which I showed, my lord, is in the context of a minority institution, which according to us, my lord, is totally inapplicable as far as government institutions are concerned. So that is the point of distinguishing, my lord, which I wanted to place for my lord's consideration. In the context of a government order, government institution, please see what happens at page 24, my lord. Page 24 of this very compilation.
That is where the in the CBSE examination, the
That's right, my lord. Where, my lord, the learned judge examines, my lord,
But this is the subsequent judgment.
yes, my lord, the
Talking about
subsequent judgment, my lord, notes that the general principle which is applicable in respect of government institution will not apply to private educational institutions. And that does not, my lord, the private minority institutions, my lord, in that case, there is no discussion on, my lords, whether it is an essential religious practice or not. Now, just if your lordships have this judgment, just turn to, my lords, page 29, if your lordships don't mind, my lord, page 29. My lords, in this particular judgment, the core issue which is there before your lordships as to whether wearing a headscarf, my lord, is a part of my lord, essential religious practice was squarely gone into, not in the other judgment, my lord, which your lordship just saw. Now see page 29, para 17. Coming back to the core issue in this writ petition about the dress code, it is to be noted that Islam embraces and encompasses guidance to human will, so and so. Then, my lords, what are the sources of Islamic law are noted. And eventually, my lord, kindly see para 24, my lord. After discussing the sources of Islamic law, including the Holy Quran, the court comes to a conclusion. My lords, in paragraph 29, my lords, I'll avoid other things. Para 29, my lord. I'm sorry, page 32. Page 32, para 29. So my time is limited, my lord. I'll just show the conclusions only. Thus, the analysis of the Quranic injunctions. My lord, the Chief Justice got para 29.
Yes.
Yes. Thus, the analysis of the Quranic injunctions and the hadiths would show that it is a farz to cover the head and wear the long sleeve dress except face part and exposing the body otherwise is forbidden. When farz is violated by any action opposite to farz, that action becomes forbidden. However, there is a possibility of different views or opinions, which the AG was referring to yesterday. This court is not discarding such views. The possibility of having different proposition is not a ground to deny the freedom. If such propositions have some foundation in the claim, as has been adverted below, the claim of the petitioners is well founded, even though a different view is possible. So lords, even if a different view is possible, the court says, if, my lord, it is the believer's faith, then, my lord, the courts have to yield to it. And that flows, my lord, from the Supreme Court judgments as well. Now, my lord, ultimately the court said that this is a facet of essential part of religion. Now, my lord, the second judgment, which the GO relies upon, is, my lord, a decision of the Bombay High Court, which your lordships will find, my lord, in the compilation itself, which is the first judgment, my lord, in the compilation. And this judgment, my lord, it's the first one in the compilation. Page 1, my lord. Page 1, my lord. The judgment starts. And see, my lords, page 2, the conclusion. Para 7, Justice Lodha's judgment, very, my lords, beautifully put. And how it is limited, my lord. Kindly see, my lord, page 2. A girl student, para 7, my lord, page 2. Yes,
Yes.
a girl student not wearing a headscarf or head covering studying in exclusive girls section. Kindly see this, my lord. Kindly make a note, which I am recommending for your lordship's kind consideration. A girl not wearing a headscarf or head covering in studying in exclusive girls section cannot be said to in any manner acting inconsistent with the aforesaid verse 31 or vitiating any injunction provided by the Holy Quran. So, my lord, this was in the context of an all-girls school. So, therefore, my lord, in a matter of co-education, this judgment is totally inapplicable. And I will just place 1 or 2 verses of the Holy Quran, my lord, because that is the, my lord, primary source of Muslim law as per Mullah, my lord, after this. Now, my lord, this judgment is not applicable. The third judgment, my lord, which the GO relies upon, is a Madras High Court judgment. And that judgment, my lord, doesn't deal with Article 25 at all. That was a case, my lord, where the teachers were asked to wear a uniform. And, my lords, under the provisions of the Tamil Nadu Education Act, whether the teachers could wear a uniform or not, that was the issue. Not even one word, my lord, about Article 25. That judgment your lordships will find, my lords, which is at page 4, my lord. I will not trouble your lordships of this very compilation. Lordships will see that judgment, page 4. My lords, there is not even one word, my lord, in the entire judgment about wearing of a headscarf or anything about Article 25. This was about prescription of head, my lords, a prescription of a dress to teachers. In that context, my lords, what are the provisions? What is the contract between the teachers and the government, my lord? That was an issue. Nothing to do with Article 25. And the government says, my lord, these three judgments are authority to say headscarf, my lord, is not a part of essential religious practice under Article 25, which I say, my lord, is a total affront to, my lords, the freedom which is guaranteed under Article 25. Now, my lords, just on this, my lord, I just want to cite one or two things on Article 25. Because I have also prepared a brief note, my lord, which has all my submissions for the purpose of interim relief. If I can request, my lord, my learned friend to just hand over that note, because your lordships will not be troubled, my lords, by going through this judgment and that judgment. I've quoted everything. In fact, my lord, the Honorable Justice Dixit had asked me to prepare a written note. I had prepared, my lord, for that purposes. So I have, my lords, put everything at one place. So your lordships, my lord, has the benefit of seeing everything at once, my lord. If I can just request, my lord, my learned friend to hand over that note. My lords, kindly see first page 3, my lord, of this note. What is the, my lords, essential practice? And I'll demonstrate. We don't have to go, my lord, to any subsidiary sources of Islamic law. Just have a look at page 3, my lord. What is the relevant verse of the Holy Quran? Page 3, my lord. My lords, if I can just place for my lord's consideration, verse 24:31, which I have reproduced in paragraph 7. And tell believing women that they should lower their glances, guard their private parts, and not display their charms beyond what is acceptable to reveal. They should let their headscarves fall to cover their necklines and not reveal their charms except to their husbands, their fathers, their husbands' fathers, their sons, their husbands' sons, their brothers' sons, their sisters' sons, their women folk, their slaves, such men as attend to them who have no so and so, or children who are not aware of women's. So, my lord, the prescription of headscarf is specifically prescribed in the Holy Quran. 24.31, my lords, I am placing for my lord's consideration. And my lords, verse 59, I have quoted over the page. My lords, apart from the learned single judge, which I have shown, my lord, who has gone into this, the Kerala High Court, and has said that this is essential practice of religion, there is a division bench of the Madras High Court, my lords, which I have placed in paragraph, my lords, 12, if your lordships just sees, my lord, over the page. Paragraph 12, my lords, page 5. I have cited all these other decisions, my lord. I don't want to trouble your lordships, but just see page 5, para 12. This is Ajmal Khan, my lord, and this is there in the compilation. Lordships will see that I have given the reference to the compilation page numbers also, and I have extracted, my lord, what the relevant portion is. And if I can just, my lord, invite your lordship's attention to the relevant portion, which is highlighted in paragraph 15, it is thus seen from the reported material that, I'm sorry, my lord, the Chief Justice got it, my lord. Para 7, para 12, my lord, I'm so sorry, my lord. Para 12, my lord. Yes, my lord. Para 12, division bench, my lord, of the Madras High Court. It is thus seen from reported material that there is almost unanimity amongst Muslim scholars that parda is not essential, but covering of headscarf is obligatory, my lord. So, my lord, we have an authoritative judicial, my lord's, determination on, my lord's, Islamic law, of course, of a different high court, which for the purpose of prima facie, my lord's, case, which I am placing for my lord's consideration. Then, my lords, B.J. Emmanuel was read to your lordships in detail. I am only placing, my lord, one portion of B.J. Emmanuel, which says, my lord, that what is an essential practice, my lord, is not to be seen from my standpoint or, my lords, anybody else's third party standpoint. And, my lord, we have to see it from the my lord's perspective of the believer. My lords, as a officer of the court, my lord, and as an individual, I may completely disagree, my lord, that headscarf should be made. My lords, anybody should insist on a headscarf. But my opinion really doesn't matter, my lord, because ultimately, my lords, we are talking about people's fundamental rights and are in a right-based society, my lord. To say that they will not be permitted, my lord, I respectfully feel, my lord, that in a matter of where your lordships is considering interim relief, your lordships will lean in favor of a situation, my lords, where people, my lord, can exercise their fundamental rights. In that context, my lord, kindly see page 6. The quotation, my lord, from Bijoy Emmanuel: if this is the belief of the community, and it is proved undoubtedly to be the belief of the Zoroastrian community, a secular judge is bound to accept that belief, and it is not for him to sit in judgment on that belief that he has no right to interfere. And then, my lord, the highlighted portion, we do endorse the view suggested by Justice Davar that question is not whether a particular religious belief or practice appeals to our reason or sentiment, but whether the belief is genuinely and conscientiously held as a part of profession or practice of religion. I respectfully submit, my lord, at this interim stage, my lord, that there is a host of judicial, my lord, pronouncement which is available. I am not requesting your lordships to only rely upon, my lord, certain verses of the Quran. I am saying those verses of the Quran have been judicially interpreted to mean that as far as headscarf is concerned, it is, my lord, it's a part of their essential religious practice. Your lordships
What we find is that we are at the end of the day.
I
You
put down, my lord.
continue arguments. You
Yes,
continue.
Yes,
We'll have it on Monday. We'll have it on Monday.
Lords, I was only requesting, my lord.
Thing is that we will request.
Yes, my lord.
We'll not only request, we will pass an order
Yes, my lord.
that let the institutions start.
Yes, my lord.
Direct that institution shall start, but till the matter is pending and consideration before the court, these students and all the stakeholders, they shall not insist for wearing any religious endowment, maybe a headdress or a saffron fatwa or anything, that we will restrain everyone, because we want the peace and tranquility in the state to be maintained, and only then thereafter the matter is before the court. We are now seized with the matter. We can continue the hearing on day-to-day basis also, and we are ready to decide the issues at the earliest. But the thing is that the peace and tranquility must be restored to the state.
My lord, so may I answer that, my lord?
This is what we find, that till the disposal of the matters, you people should not insist for wearing all these religious things which are not conducive
My lord,
sir, may I submit, my lord?
my lord, I'm required to wear a
Mr.
dupatta.
Hegde,
I'm required to wear a
just 2 minutes.
dupatta. How they wear it?
Yes,
Please,
Mr. Hegde,
let them not
lord,
object.
may I just respond to that, my lord? Now, what your lordships are saying, my lord, as an officer of the court, my lord, I respectfully submit, my lord, that would amount to a suspension, my lord, of Article 25 as far as the students are concerned.
Whatever
Lord,
it is, you may take it.
Lord,
But the thing is
Lord,
that if you want us to decide these issues,
yes,
which we also find it of some constitutional importance,
yes, my lord, yes, my lord.
then you will have to cooperate.
Lords,
you will have to cooperate.
Lords, my
And have
cooperation,
the faith on
Lords,
the
kindly see, my lord, we are being asked to choose between food and water. My lords, kindly see, both are essential.
No, it is
Please
not a matter of
please
food.
don't, my lords, please don't, my lord, mistake us. We are asked to choose between education and our conscience. Please don't, my lord. I respectfully submit, my lord, these are matters of moment. Lord, this is not
you
a
have
matter,
approached the court. You have a faith on the court. Let them
absolutely,
have
my lord.
faith.
There is no doubt
Yes,
about it.
then
But I
wait
would
for
like
some time.
Yes,
Wait
my
for
lord.
some time.
Lords, I
Don't
am just
insist.
saying, my lords, I am just saying, my lords, your lordships are completely, my lord, we are in the lordship.
Yes, we will pass the order.
But as far as interim orders are concerned, kindly note my submissions, my lord.
We are in the midst of the arguments. We
Yes,
will
my lord.
hear you on the interim order.
I
We are
go down,
hearing
my lord.
you.
I bow
Yes.
down, my lord. Lords, kindly note
Lord,
my submission that
Lord,
if your
may I-
lordships, my lord, direct that these students have to go without their headscarf, my lord, that would be a total affront to their rights, because your lordships have not determined whether they have a right or not. Today, I have demonstrated to
It
your
is a
lordship
matter of few
that we
days
have a
only,
prima facie
Mr.
case.
Mr. Kamath, please
Yes,
try to
my lord.
understand the situation.
Yes, my
It is a
lord.
matter of few days only.
My lord,
But,
That
I
is
with
this
completely,
respect,
which
my
was
lord,
there,
with
existing
respect, my
there in
lord,
the state. May
yes,
we
I vote on
restore
it.
for few days.
Yes, my lord.
my lord, that's the problem.
Lordships,
A few days,
just 10
I
seconds, my
can't
lord.
suspend my
Lordships,
faith.
yes. My lord, just 10 seconds, then lordships
my
may
lord.
kindly record.
What we
my-
find, all right, we will pass the order. We are not
Yes,
asking
my
for
lord.
your
Lordships may
comments
pass
on
the
that.
order, but please
Yes.
record my lord's objection that this kind
Yes.
of an order, my lord, at this stage cannot be passed. But please
All right,
record
all
my objection. That's my only submission, my lord.
Lord, may
Please
I
record my
make
objection
one
on
We have
submission, my lord?
given you our mind.
Lord,
That
may I
since
make
we
a
are
request,
finished with the
Lord?
matter, we will
Yes.
restrain everyone
Yes, my
from
lord.
adopting all these
Very well.
practices.
Yes.
Yes.
My lord, may I make one request, my lords? I appear for the petitioner in WP 2347, my lords. My lords,
We will hear everyone on the next date.
Yeah, one submission, my lord. So one more writ petition is connected with my lord, that has to be connected. 3148 of 2022.
Just a
it's been
minute,
filed
somebody
today.
is speaking, we cannot hear.
Please, NAP dividing rule policy politician का पैसा हो गया है, अभी हिंदू मुस्लिम का डराटा ज्यादा हो जाएगा, इसके लिए एक मीडिएशन हम लोग को भेजिए, नहीं तो we will do the compromise. I want the politicians even मोदी साहब इतना बोल रहे हैं, मैं इतना किया करती, क्यों नहीं आ सकते डॉन में, आके सबको कॉम्प्रोमाइज क्यों नहीं कर सकते? एक लड़की का
All right, all right.
अगर वो मरेगा तो
Let's-
she can get suicide. मरेगी मैं नहीं पहन के आएगी ऐसा बोलते हैं. So please, my lordship, send it for VLC, for VC mediation. compromise. हम लोग कनेक्ट
The matter again on Monday at 2:30.
Lord, may I make a request, Lord? May I make writ petition number 3148, which may kindly be connected with me.
प्लीज मैं हो जाएगा पूरा लड़की लोग मैं मर जाएगी करके भी बोलते कौन उसका जिम्मेदार होता है हमको कॉम्प्रोमाइज करने के लिए ये मीडिएशन के लिए रेफर कीजिए मीडिएशन मेनी केसेस सुप्रीम कोर्ट में मीडिएशन के लिए